In a country as richly diverse as India, where a multitude of religions, cultures, and languages converge, the concept of minority rights is not just a legal obligation, but a social necessity. Minority educational institutions stand as beacons to this very commitment, the commitment which exemplifies India's promise. India's promise to ensure that heritage, culture, and identity of every community is protected. Doesn't matter how small, doesn't matter how distinct that community might be. These institutions, however, do more than just preserve traditions. They act as bridges, moments of opportunities, so that communities that have been marginalized, often due to the lack of access to education, are able to see the light of day. Yet, this extremely noble endeavor raises some very, very complex issues. Can minority educational institutions maintain cultural autonomy while promoting inclusive education for all? Should state funded educational institutions cater primarily to one such community? And at the end of it, how does one strike a balance between the freedoms that these institutions enjoy and the responsibilities that they bear towards society at large? Recent judgments of the Supreme Court and debates around the Aligarh Muslim University and the role of madrasas in India's educational network force us to confront these complex questions head on. It challenges our very notion of equality, autonomy, and the very fabric of secularism. And as we delve into these complex legal, social, and financial frameworks, we encounter a landscape which is as intricate as India's cultural mosaic. At the heart of it all lies a very delicate balance. The balancing act is honoring the right of every community to ultimately educate its own. And while you do that, how do you uphold the spirit of an inclusive, united India? And this exploration of minority educational institutions is therefore not just an examination of law and policy, it's a window into India's ongoing journey to becoming a diverse ecosystem. A reminder that education and the right to education goes hand in hand with the right to one's identity. Ladies and gentlemen, this is What a Week, our weekly current affairs presentation giving you a 360-degree on a contemporary issue, giving you closure because no one else will. For those of you preparing for the civil services, don't get too rattled by the immediacy of the content that you consume. While I understand that the recent Supreme Court judgments give us enough to think about, but in reality, the UPSC is far more contextual and far more nuanced. So, a topic like this to be placed in the syllabus is always to be done in an academic manner. Secularism, which is a common topic to paper 1 and paper 2, directly relates to minority institutions. Secondly, within paper 2, under the topic bodies, the efficiency of the bodies responsible for advancement of their causes is where it actually becomes important. And that's pretty much it. Through the course of this presentation, I would be answering 7 fundamental questions. One, we'll first begin by defining and understanding the purpose of minorities and minority institutions. Second, we will delve into the legal frameworks and the larger policy in play as far as minorities and their institutions are concerned. Thereafter, we will then move to understanding the aspects of funding and resources. Moving on, we will therefore be looking at their role in promoting inclusivity. And once we understand that, we will then move on to understanding the nuances behind their curriculum and their autonomy. And once we understand that, we will then move to understanding the kind of impact that they've had on the minorities who they're supposed to promote and protect. And while we do this, we thereafter move on to understanding the kind of benefits have they brought to the fore. And finally, we will be looking at some of the current debates, controversies, and challenges surrounding these institutions at large. Let's start with the first question, the definitions and their purpose. In this, we'll be answering 3 things. 1, who are minorities? 2, what are minority institutions? And 3, why are minority institutions even set up? Let's start with the first. Who are minorities and how are they defined? Minorities in India are broadly classified by religion or language. Though the Constitution of India does not explicitly define the term minority, even though it mentions it. The National Commission for Minorities Act of 1993 recognizes 6 communities as minorities. These 6 communities are Muslims, Christians, Sikhs, Buddhists, Parsis, and the most recently, Jains. And all of these have been identified as per religious affiliation. If you look at their numbers, we would refer to the census of 2011, where minority populations constitute a total of 19.3% of our total population. If we sub-bifurcate it, India's largest minorities, the Muslims, comprise about 14.2% of our population. They're closely followed by Christians with about 2.3%, Sikhs at 1.7%, Buddhists at 0.7%, Jains at 0.4%, and Parsis at 57,000 only. So the question is, how are you defining them? The Supreme Court, in its landmark judgment, the TMA Pai Foundation versus the state of Karnataka in 2002, categorically laid down the law for this. It said the minorities should be defined only on the basis of state demographics, which means that any community which is a minority, which has less than 50% population in that state, constitutes a minority in that state. This basically means you can approach to protect the rights of linguistic minorities, such as people who are Nepali in West Bengal, people who speak Urdu or Kannada in Tamil Nadu, or people who are Gujaratis in Maharashtra. Which then brings me to the second question. What are minority educational institutions? So, minority educational institutions are either schools or colleges that minority communities establish to serve their cultural and educational needs. They are established under Article 30, Clause 1 of the Indian Constitution. And this provision gives them the power to govern themselves autonomously, more specifically with regards to their admission process, their choice of curriculum, and often administrative measures. And this leads me to the third question under definitions. Why would you even set something like this up in India? The establishment of minority educational institutions is aimed not only at cultural preservation but also providing educational opportunities to people who may seemingly be disadvantaged. And this is so that the education that is provided is specifically customized, is specifically tailored on the basis of language, religion, and cultural needs of these very minorities. When we look at Articles 29 and 30, they were specifically designed to promote inclusivity and cultural pluralism in education. And by doing this, you would empower minorities not only to conserve their heritage, but also access quality education simultaneously. Moving on to the legal frameworks and the larger policy ecosystem. When we look at an overview of everything that comes into place to ensure minorities get their due, you have the Constitution, you have a plethora of Supreme Court judgments, you have the Ministry for Minority Affairs, you have the National Minority Educational Institutions Authority, you also have affiliate state level bodies to comply to these guidelines, and therefore it becomes a very complex intertwined web of provisions, judgments, ministries, and bodies. Let's start with the constitutional provisions. The right to administer and the right to establish minority educational institutions has been enshrined under Articles 29 and 30, while Article 29 guarantees the right to every citizen to conserve language, script, or culture. Article 30 specifically empowers minorities to establish and administer educational institutions, which means there is a relationship between Articles 29 and 30. If you look at Article 29 grants every citizen the right to preserve their own culture, script, or language. The intent here is to protect minorities, but it also applies to all citizens. While Article 30 is exclusively for minorities, it grants religious and linguistic minorities the right to establish their institutions and therefore exempting them from certain governmental mandates and other policy decisions. So, Articles 29 and 30, though written together, have a very differentiated scope of functioning. And minority rights don't start and finish with Articles 29 or 30. Several other provisions of the Constitution, such as Article 14, which is equality before law, Article 15, which prohibits discrimination, Article 19, the right to practice any profession, occupation, trade, or business, Articles 25 to 28, which generally govern our freedom of religion, have an intersection with 29 and 30. Some of them have a positive relationship, while some can have a conflicting relationship. For example, Article 14's equality mandate can conflict with preferential treatments that are given to minorities. However, if you look at secularism provisions under 25 to 28, they actually support religious minority institutions. And while the Constitution tries to do its job, it's really the Supreme Court that has taken the show away. There are three Supreme Court judgments that are essential to understanding the rights of minority educational institutions. It starts with the St. Xavier's College versus State of Gujarat in 1974. Here, the Supreme Court reaffirmed minority institutions' rights to appoint their own teachers, their faculty members, their ways to select students, to determine curriculum and educational content, and to broadly uphold autonomy. In 2002, in the landmark case that we've discussed before, the TMAPI Foundation case versus State of Karnataka, the Supreme Court actually laid down the criteria for defining minorities. And not only this, it also gave you a detailed discourse on the extent of administrative autonomy that minority institutions could actually exercise. And finally, in 2014, in a rather landmark judgment, the case is called the Pramati Educational and Cultural Trust. The Supreme Court exempted minority institutions from provisions of the Right to Education Act. It exempted them from compulsory student quotas and reinforcing the RTE Act to minority institutions in the first place. This is besides the fact that reservation articles of 15, which allow for educational reservation under 15.4, 15.5, and 15.6, do not actually apply to minority educational institutions. And while the judgments have also played their role, a very crucial institution in this entire ecosystem is the National Commission for Minority Educational Institutions. Yes, we have a National Commission for Minorities, but the subject matter of today's discussion is this specific body for minority educational institutions. This is a statutory body set up under the National Commission for Minority Educational Institutions Act of 2004. Its job is to certify the minority status that is given to educational institutions. Its job is to offer legal recourse and to safeguard autonomy when threatened. The Ministry of Minority Affairs, which is also a very, very young infant ministry, set up just in 2006, also develops the policies for funding and supports the infrastructural requirements of these minority institutions. So then the question is, how does an institution become a minority educational institution? It is the Supreme Court again which has laid down the criteria for this. Now, you could call it an act of judicial activism, but I leave it to your wisdom. But the Supreme Court has identified a very categorical list of things that an institution must fulfill for it to be a minority educational institution. These things include number one, they must be established and primarily administered by a minority community. Two, it should cater primarily to the needs of that very minority community. And three, the state government or the national commission identifies and certifies this institution's status after reviewing its purpose and administrative frameworks, which means the government plays a very strong role in identifying whether you are a minority institution or not. Funding and resources. While minority educational institutions are absolutely entitled to state funding under Article 32, that does come with a catch. No doubt, the government cannot discriminate against minority institutions while distributing educational aid amongst them. But the minority educational institutions must also ensure that they comply with whatever educational standards that have to be complied with, and not just this, also sometimes admit a significant proportion of non minority students to the same institution for larger purposes. Now, there are some challenges in securing these finances. One, there is a strict dependency on grants. Many minority institutions depend heavily on government grants, and this requires a strict adherence to regulatory conditions that can actually sometimes limit their autonomy. Two, private funding is extremely limited. While some institutions may want greater autonomy, they avoid greater government aid by limiting their financial resources. So, on the one hand, you can either want more autonomy, but that means you'll have lesser resources because most resources are actually released by the state. Another challenge is the competing government schemes. While schemes like the pre-matric scholarship program has benefited more than 4 million students in 2021, and the Maulana Azad National Fellowship supports many a million. The problem is the resources aren't enough. The demand, more often than not, exceeds supply. Curriculum and autonomy. The Supreme Court has played a significant role here. Three judgments of the Supreme Court, the TMA Pi Foundation case, the Islamic Academy judgment, and the PA Inamdar judgment of 2005, have given extreme clarity on such autonomy driven problems. So basically, what has happened is three categories of minority institutions have been identified. The first, those who do not need any recognition, affiliation, or any aid. For these kinds, the state cannot interfere in any manner. The second type, those who need recognition or affiliation but do not need any aid from government. In this scenario, educational rights that are granted to minorities can be regulated and are also subject to a fair degree of reasonable restrictions. And these could be in the nature of maybe prescribing educational standards, qualifications, eligibility conditions at the time of granting such an affiliation. The right to administer does not mean the right to maladminister. And thirdly, those who need aid from government. Here, they're not supposed to lose their character as a minority educational institution, but they do come in the domain of Article 29(2), which means they will have to sprinkle a degree of outsiders to comply with the mandate of Article 29(2). Amongst all of this, a reasonable fee structure without the motive of profiteering and recognition and affiliation conditions must always be complied with. See, minority institutions, particularly the unaided ones, will tend to enjoy the highest degree of autonomy. This autonomy would be in their curriculum, in their administrative structure, and so on and so forth. But there are, of course, a degree of limitations. One, if you do require aid, you will have to administer students from outside. Two, if you want affiliation, you will have to comply with standards. And three, while you can take fees, you can make a killing out of it. Let's now understand inclusivity. Minority institutions are never exclusively for minority students. They more often than not can admit non minority students so that there's always a larger culture of diversity. This sense of inclusivity has been the cornerstone in several cases, such as the St. Stephen's College versus University of Delhi. In this case, the Supreme Court held that a minority institution can admit a small proportion of minorities of students who come from other communities without compromising their minority character. And while you're doing this, the minority must always be a majority in a minority institution. This allows for a very sensitive balance in such diverse educational institutions. Let's now look at the benefits that have actually occurred. See, minority education institutions play a significant role in emancipating minorities. That's a given. Let's understand how deep this goes. Take, for instance, the rates of literacy for Muslims in India. Muslims in India have lesser literacy rates compared to other groups. For instance, if the national average literacy rate is 74% as per the census of 2011, Muslims are literate to the tune of 59%. So institutions like the Jamia Millia, Aligarh Muslim University have been instrumental in closing these gaps. And Aligarh Muslim University, a Jamia Millia, a St. Xavier's College, Mumbai, have been institutions of excellence. And some of them also enjoy global recognition. In situations like these, institutions like the Jamia Millia Islamia and the Aligarh Muslim University have not only tried to bridge these immense educational gaps, they've also become institutions of national and international repute. So, an Aligarh Muslim University, a Jamia Millia, and maybe the Xavier's College, Mumbai, they're all institutions extremely tough to get into, and they hold a value like very few other. Let us now finally look at the challenges and the way forward. So, in the recent past, we've had two extremely important Supreme Court judgments. The Supreme Court, on one hand, laid down parameters to identify a minority educational institution and directed a regular smaller bench to determine the minority status of the Aligarh Muslim University on the basis of these parameters. On the other hand, the Supreme Court held that the UP Madrasas Act was only unconstitutional to the extent that it granted higher education degrees beyond class 12. So there is a fair degree of judicial intervention, and this leads to a larger set of challenges. There are regulatory conflicts, there are funding constraints, and there are socio political pressures. And while all of this happens, the way forward is fairly simple. One requires greater accountability and transparency, one requires a larger scope of funding, and finally, a more exclusive and a more expansive understanding of inclusivity. Ultimately, minority educational institutions represent a testament to India's foundational ethos. This ethos is that diversity is not a weakness but our strength. In fostering these spaces with sensitivity and foresight, India reaffirms her commitment to an equitable society where every community not only has the chance to conserve its own identity, but also to contribute fully to the best of its ability to the nation's shared future. And in pursuit of exactly this, these minority educational institutions hold the promise of a more inclusive and a more just India. An India that not only accepts diversity but celebrates it, celebrates diversity as the very cornerstone of our democracy. Thank you for watching.